Okay, everyone's fallen silent, which is an excellent time to start a panel, particularly the last panel of the day. My name's Emily Bell. I'm the director of the Tower Centre for Digital Journalism over at Columbia Journalism School on the other side of several quads. Normally I'd apologise for being the last panel of the day between you and the bar, but I'm not going to because we have a really stellar set of individuals here who are going to talk about freedom of expression in the context of digital rights, and we've asked our extremely distinguished panel to both have a look back at the last 12 months and a look forward at the next 12 months to pick out highlights. To introduce the panel, to my immediate right, not politically, I think, Mark Stevens. I love that joke, because the moment they cease letting me sit people to my right, I'm lost.
I'm about to move to the Trump position.
Mark Stevens from Howard Kennedy, a tireless campaigner and leading lawyer on press freedom. Then to his right, sorry, I'm now not going in the order of the panel, Mishi Choudhary, who is the Executive Director of the Software Freedom Law Centre. To her right, possibly politically, wouldn't like to guess at that, we have Ross LaJeunesse, who is the Global Head of International Relations at Google. To my immediate left, probably politically, don't know, Bertrand Chapelle, who's Director of the Internet and Jurisdiction Project.
Well, French, it's good.
And French, yes, so as Rebecca quite rightly points out, almost certainly. In fact, he should be sitting in a different building over there. And then to his
I
left.
couldn't help it.
No, it's good. I like this. Gags at 5 o'clock on the second day of a conference is always welcome. And then immediately to his left, Rebecca MacKinnon, who is a fellow of the New America Foundation and also a pioneering journalist in terms of sort of both thinking and creating organisations like Global Voices in this space. And then to her left we have Andrew McLaughlin, who has so many things that I could say about him, but at the moment I would say he's just joined Medium, where today he has been launching a new suite of publishing tools for publishers. But prior to that, he was at the White House as Deputy CTO. He's been at CEO of Dig. He has been at Google as well, so has seen this debate from, if you like, both publisher and platform sides. So, without more ado, I'm going to just sort of ask each of the panel to make their opening remarks on this. Some have slides, some don't, so it'll be a great surprise to you as to what you get next. But I'm going to ask Mark to kick off.
Well, thanks, Emily. Emily said to me, will you tell us what we're going to be talking about next year, Mark? And I sent her an email over the weekend which had 9 things on it. And she said, well, that's rather a lot. I still stand by the list of 9. But I thought what I would talk to you about is where Britain is an absolute world leader, and that's the Investigatory Powers Bill, which is currently wending its way through Parliament in the UK and will be law by December this year. The Investigatory Powers Bill gives effectively every kind of conceivable law enforcement the ability to capture and get into content data as well as data of communications. Now, you have to sort of understand that we in Britain have had a long and less than virtuous progress towards this place where effectively the things that Edward Snowden were revealed have now been or are now in the process of being put on a statutory footing. So back in 1984, in a case called Malone against the UK, Strasbourg found that the UK's phone tapping arrangements were in breach of the European Convention on Human Rights. So that brought us to the Interception of Communications Bill in 1985, and that was criticised in Halford against the UK in 97. Which led in 2000 to the regulation of investigatory powers. Don't you love this kind of, who do you think you are history of the genus of legislation? Then we got the Snowden revelations, and that brought in more scrutiny from Sir Nigel Sheinwald, a very eminent, senior civil servant at the in the government, and an independent, David Anderson, who is quite a well-respected QC. And he entitled his, rather interestingly, The Price of Trust. And that led us to this year, the Investigatory Powers Bill, which effectively is said to overhaul all of the complex legislation around spying, bugging, gathering communications, all of those things. The laws and the regulations in the UK are so complex that even the lawyers at the MI5 and MI6 don't understand them. So mere mortal lawyers haven't got a prayer, and certainly the public don't. So the one thing that we do say is, because of that, everybody agrees that there needs to be a new state of laws. So I think that we've got this communication data mapping, and basically companies are going to have to hold, or they're making a difference between communications data, i.e. that's the manner of communications occurred to whom, and you can see any of that without a warrant or any judicial oversight. The content of those communications, what the person actually said or sent, may need some kind of oversight, but not judicial oversight, something I'll come to. So companies are going to have to hold connection records for a year. The intercepts and reading of communications have to be approved by a politician, the Home Secretary, Theresa May in this case. And they can also authorize interference with computers, hacking in order to acquire information, and also putting of bugs and other software things onto your computers. There's a legal obligation that's being imposed on the companies to assist and the legally, officially sanctioned hacking operations. And the collection of these massive amounts of phone data are there, obviously, so it can later be assisted. We can have encryption, thankful for small mercies, but the companies have to help decrypt in the event that they can do so. So we never get into the FBI and Apple case. That's gone. We've sold the pass on that. So what are the safeguards? Well, we've got a politician in charge of bugging and intercepting of communications of lawyers, including in cases against the government, of journalists, of doctors, as well as members of the general public, which I think is perhaps slightly worrying. And they were slightly concerned at some of the criticisms about this, that perhaps a politician wasn't the right person to do it. So they put a double lock on it. And so they decided to sprinkle some judicial fairy dust over the top of it to make this all okay. And the judicial fairy dust is a couple of old retired judges who are approved of by the security services, who have to say, not sitting in a judicial capacity, so they're not judicially reviewable, but they have to say, yes, we like what the Theresa May, the Home Secretary, the politician, has done. So the question is, do we think this is compliant with the Human Rights Act? Well, probably not. And what's bizarre about this, I find myself in the same position as the lawyers for the security services. The lawyers for the security services want clarity. I'm not so sure I do, because I think I want cases, but it's clear to me that there's going to be an absolute bean feast for lawyers here, because nobody knows what the law is going to be after all of this. It's a complete mess. So for Americans in the room, there's no probable cause standard, so you don't have to show that a crime has or is about to be committed in any way, or there's suspicion about it. So I think that there's real concerns about this. I'm not sure that we will find this compliant with the Human Rights Act, having been whipped twice by Europe. I suspect we're up for a third thrashing, but of course that's a very British kind of peccadillo. And so I think that, well, if you follow Max Mosley, it is. And so I just thought that we should just be a little bit nervous about the Investigatory Powers Bill, because it does affect all of us, but it's also going to affect particularly journalists and lawyers. So have I got time for one more?
Yes, you have. I was going to say, they're still laughing, so you have time for one more.
Okay, right. This is less of a laughing matter, I'm afraid. I mean, that's just so ludicrous. Couple of things. I'm particularly troubled by network shutdowns and throttling. Throttling, of course, is where you remove the bandwidth so that your computer doesn't load or work. Now, people in Egypt and Turkey will be very familiar with this. It's spreading, and the problems that we're seeing is with network shutdowns is that very often, we've had the benefit of all the regions, but now we're going to look at this sort of a more global basis. On the global basis, most countries don't have a process, an official process, for asking the telcos to throttle or turn off the networks. And that is, I think, the vulnerability of governments when they ring up. And we have the situation in Congo-Brazzaville. A few weeks ago, we had an election, and the government rang up and said, well, we've got the election tomorrow. People are saying very bad things about us. We'd rather like you to turn off the networks, please. And they said, well, could we have a fax at least, please, requesting it and identifying the power? That never came, and they were told that if they didn't turn off the networks, they'd lose their licenses. So I think that those are issues that are going. The big thing today is that El Salvador has issued a presidential decree, so they learned something from down in Congo-Brazzaville, and that is that there have been so many escapes from prisons using cell phones that they've now switched off all the cell towers near prisons. So if you happen to have the misfortune to live within 100 yards of the local prison, you can't get cell reception or indeed internet reception. And this is affecting hundreds of thousands of people and appears to be perfectly okay and proportionate. So that's that particular issue at the moment.
Thank you very much indeed, Mark. The Investigatory Powers Act does not make me proud to be British, but you do, however, so that's a good thing. Rebecca, can I turn to you next?
Thank you very much, Emily. I'm afraid I've asked our friends in the back controlling the computer to do something slightly unusual. Instead of a PowerPoint, I decided I was sick of PowerPoints and I was just going to show some websites, and we've got them queued up there, and let's see if it works. How are we doing? Okay, yeah, so I just wanted, since this conference has been talking about the law for the last 2 days, I thought I would start by reminding everyone of a book written nearly 18 years ago by the cyber law, really the creator of the cyber law field, Larry Lessig, who wrote Code is Law. And so in the digital space on the internet, it's not just legal code that is affecting what people can and cannot do and shaping people's rights and freedoms, but also computer code and engineering design is also affecting what people can and cannot do on the internet. And in addition to that, there's one other set of non-legal code that is increasingly impacting people's rights on the internet, which is the private terms of service, terms and conditions, community guidelines, whatever you want to call them, the private rules that internet companies in particular, but also other companies that provide services on the internet set up that are extra legal in nature and which they're legally allowed to do, but which often, particularly in Western democracies, tend to restrict speech that is actually protected under law, but can restrict it more narrowly. So Facebook's terms and conditions being an example, and I'll talk a bit more about that. So I wanted to talk about really, I think the major trend in 2015 and coming into 2016 is growing efforts by policymakers to impose legal code, to use legal code to further shape, restrict, impose restrictions on the private code, both computer code as well as terms and conditions that impact and shape freedom of expression and related privacy privacy issues. So both in the technical sense as well as in the private rules sense, being shaped by kind of legal demands and requirements. And at the same time, we're seeing policymakers delegating thorny problems that they don't really want to deal with or being held accountable to the private sector, to computer code, and to private rules code. And so if we could move to the next tab there, oops, yes, so that's Right, if you could click on that link that says Amnesty International Report. Yeah, that red one there. Yep. So Amnesty International recently came out with a report about the relevance of encryption to human rights and freedom of expression. And some of you will be familiar with the report by the UN Special Rapporteur on Freedom of Expression, David Kaye, on encryption that he issued last year, and connecting the need for encryption to the right to freedom of expression. So I would refer all of you to that, and I won't repeat, but of course, in the news, there's been the Apple case and the demands by the FBI for Apple to basically rewrite some code and break the encryption on its phone, and broader debates that can relate to some of what Mark was talking about in terms of whether governments should require so-called backdoors into encrypted communications by companies, or ban encryption altogether. And we've seen a number of countries that have banned encryption or have basically banned certain services from within their borders because they offer encryption. And actually Facebook has a version of Facebook Zero on which they encrypt communications, and Egypt banned that recently. And they actually cited other reasons having to do with net neutrality. I'm not going to go down that rabbit hole here, but the actual reason is that they didn't want Facebook to be offering encrypted communications on their network. So that's sort of one example. Another story that's been less in the news, if you want to go to the next tab, with WhatsApp. WhatsApp, which is a messaging service that's now owned by Facebook, just today announced that they have rolled out encryption on all of their services. So to all their users in the world. And we're really seeing kind of a clash between the companies that write the code and the governments that write the legal code, and a serious conflict here. And the question is it going to end badly and in a very ugly way for freedom of expression, or are we going to work out solutions that actually enable freedom of expression and human rights advocacy to take place? And one interesting story that you're less familiar with probably than the Apple story is that Facebook recently in Brazil had an executive who was put in jail for about 24 hours because Facebook was unable to hand over the communications of a WhatsApp user because they couldn't access them because they were encrypted. The judge did not understand this and threw an executive in jail. And I'm afraid we're in danger of increasingly having this kind of situation coming up as we have companies kind of trying to provide secure communications environments for users, and governments increasingly basically saying that they cannot accept that, and where do we go from here? My own view on this is very consistent with Amnesty's and with David Kaye's, that we need encryption, that the bad guys, so-called, are always going to find a way to use encryption. And if you ban encryption or weaken security on the internet, the people who are going to lose are the journalists, the human rights activists, and the innocent people who are trying not to have their bank account content stolen. So that's, and then moving on to kind of the other, we'll go to the next tab, in terms of other forms of code. I've been involved with a project called Ranking Digital Rights, where we're evaluating companies' policies and practices, and a lot of it has to do with how companies respond to external requests, to what extent they're transparent about what they're removing or handing over, and so on. And just to go to the next tab, and you can go online to Ranking Digital Rights Org and see kind of the report. And we have a section on freedom of expression and how companies are doing in relation to freedom of expression. But if we go to the third tab and go to, or the next tab here. So so here we're asking some questions about whether companies disclose, whether they have a clear policy about how they notify users when they take down content, and only some do. And then if you scroll a bit down to show F6 there, just scroll down on the page, the process for responding to requests. Does the company disclose anything about its process for responding to government requests? Only half of the companies we looked at disclose anything about that. If you scroll down further to F7, data about government requests. Do the companies issue what are called transparency reports, data about how many government requests they've received to either take down content or block content or shut down accounts or networks? You'll see that even fewer companies disclose any data. And if you scroll further to F8, you'll see that a lot of companies are receiving private requests to remove content and block content. Even fewer companies disclose anything about the private requests they receive. And if you scroll further to F9, do the companies disclose any data about the volume and nature of content they're blocking and removing as they enforce their terms of service? None disclose anything. Right? And so then this is happening in the context of, and I'm running out of time, so I might not show everything, but I want to show you, skip quickly through a couple of slides. These two, if you go to the next tab, we're seeing increasingly, because of certain policies, for instance, Facebook requires that people use their real identity online, and there's some governments that are actually imposing real ID policies on social networking services. In Zambia, you have a situation where somebody who's complaining about the government, gets identified and tracked down. You go to the next tab, again in Thailand, where it's becoming illegal even to imply criticism of the king. You have people again being tracked down. I would refer you to a very interesting resource, onlinecensorship.org, on the next tab, where this project run by the EFF and a number of other organizations have just released a report, coming to the next tab, about sort of data about contents that's being removed by companies in the enforcement of their terms of service, and the extent to which the appeals processes are unclear, the extent to which users don't understand why their content is being blocked, and just really demonstrating with case studies the total lack of transparency in the way in which journalists and activists are being swept up. And this is of particular concern, going to the last tab, because we're now in a situation where governments increasingly, are trying to combat violent extremism on the internet, and this has been discussed earlier, and are turning to companies and saying, you need to use your terms of service more aggressively. You need to sharpen your terms of service and take down more violent extremist content. And so they're also, in Europe, there are these reporting units now that are flagging content for the companies to take down. This is not going through any kind of legal process, no due process. The company, we have no idea what the governments are flagging, what's being taken down. And every once in a while you hear strange anecdotes, like women named ISIS have their accounts deactivated on Facebook. And you also hear from various journalists in Syria and Egypt and elsewhere about content being removed for mysterious reasons and then not really being able to appeal. So I'll just close in saying that sort of make an appeal for, I know this is sort of a law conference, but if we're really trying to understand the threats to freedom of expression and kind of where the cutting edge is, we might consider going a little bit beyond legal code and consider some of the other codes and how they interact with one another in order to get the full picture. Thanks.
Terrific. Thank you very much indeed, Rebecca. So we've heard about the push from governments and now the, as you say, sort of code which is exercised in the commercial sphere. Andrew, what's your perspective?
Well, so we should first I think, just acknowledge that it's been a bad year for freedom of expression, right? I mean, we're living through a sort of a dark period right now, and I think it's worth, calling that out because it's all around us. So the two great axes of conflict online are around censorship and surveillance. These are the two battles that are being fought. Increasingly, they've converged. I think that's one of the themes from the last year. But they've converged in interesting and often surprising ways. And I think it's worth unpacking them a little bit. So big theme number one is around censorship, or freedom of expression, if you want to talk about it positively. And that is efforts to extend national jurisdiction globally. So the singular feature of the internet that makes it interesting for a group of lawyers like this, the internet as a network, is that it is extraordinarily borderless in its technical architecture. So the thing that makes the internet interesting is that it crosses borders. Packets are switched essentially without regard to national borders. Now, the real story of the topology of the internet is a little bit more complicated than that. Of course, networks exist in physical space, but the way the routing system works, the logical software layer of the internet that moves communications and content around, is one which is essentially agnostic as to nation. And so the great conflict is that national laws are formulated within bounded physical space. There are borders within which the law is said to apply, and then there's the rest of the world. And the internet disrupts that and has disrupted that. So the big trend in 2015 then is, through a variety of mechanisms, we see the nation states attempting to reassert the border. And then beyond that, we also see states now trying to exercise their will on the companies that operate the infrastructure that cross the borders. And so this is interesting because, unlike many of the other sort of like public goods infrastructures that we think about in the literature, the internet is operated by a set of companies, mostly headquartered in California, mostly incorporated in Delaware, and at minimum subject to United States jurisdiction. So one example is the European Union's catastrophically terrible right to be forgotten, in my view, that the French CNIL, their privacy regulator, has now decided must be enforced globally. And they've begun levying fines. I think Google's, a couple €100,000 into being fined. Several millions of dollars of fines have been levied on other companies. And what the French CNIL is saying is that it is a mistake to frame their private censorship right, which is what the right to be forgotten is. It gives private parties the right to use the apparatus of the state to enforce a censorship order on a private company. Bizarrely, a search engine for the top-level search results and nobody else. It's an extraordinarily unprincipled policy. But anyway, what the French CNIL has said is this is not a freedom of expression issue. This is a moral right to control over one's own information. Information which is outdated, which is irrelevant, which is unfair in some sense to have be public. And regardless of the fact that other people may want to talk about it, regardless of the fact that there may be a historical fact rooted in some web page on the internet, we are going to give that individual the right to control how they are presented to the world through the homepage of search results that are keyed off of their name. And that right, because it is not a freedom of expression right, it is a moral right, in their view, to privacy, must be enforced globally. That person must be able to control the presentation of their reputation and so forth around the world. And so the French CNIL has now said that Google must censor search results not only for users physically in France, not only for users who go to a French denominated top-level domain like google.fr, but globally. All interfaces, all countries, and all users. I think this will, of course, go nowhere. I think this is it's predictable that this will not succeed because most of the world will regard this, I think, correctly as a censorship demand. But that is an example of it. Of course, China for years has been attempting to exercise extraterritorial jurisdiction of its own censorship requirements. Most alarmingly in the case of Hong Kong and the various ways in which they're trying to exercise control over what had been a one country, two systems island of freedom of expression within China. They do it through ISP level censorship. They do it through, more recently and more alarmingly, the arbitrary arrest and detention, in some cases kidnapping, of disfavored journalists writing things about the families of the leadership in Beijing. Interestingly, in the US, actually, we're now seeing the same thing, which is you see not executive branch officials in public, but certainly members of Congress pounding the table and demanding that American tech companies censor globally speech which they believe is an incitement to violent extremism. And a footnote about this, by the way, which I think is very interesting, this is just a legal footnote, I guess, more than anything else, is that the world really does face this very interesting conundrum around, for example, videos produced by ISIS that include footage of beheadings of their prisoners in the territory they control. What's so interesting is that it is at the same time propaganda, absolutely. It isn't the publication of that kind of video footage is an atrocity. It's a crime in every sense of the word, and an attempt to propagandize their cause. On the other hand, it is also documentation of a news event, of a historical event, of something that has just taken place. And by demanding that that be censored, I do sort of worry that in order to stop the propaganda in one context, we are purging or whitewashing the horror of what's really taking place in ISIL-controlled territory. And it's a great example of the an inevitable law school exam question about context and how words, symbols, and even documented events can have different meanings, different legally significant meanings based on the context in which they appear. The other part of this trend, which I think is worth calling out, is that the effort to assert national borders has recently taken the form of governments saying data must be stored within our borders. So tech companies have traditionally had two broad mechanisms for fighting against efforts to assert national jurisdiction. The first one is by saying we have no infrastructure or people in your jurisdiction, none of the usual minimum contacts that international SHU-type jurisdictional analysis calls for exist, and so therefore we are not subject to your jurisdiction. As a practical matter, a tech company that doesn't have infrastructure in a given country has nothing to be seized. There's nothing to be attached. There are no revenues to be impounded, and so no staff to be arrested. And so the tech companies will traditionally think long and hard about putting servers or people into a country or employing them there, and assume that once they do cross that line and have that infrastructure or those people, they're subject to the jurisdiction and so forth. Many countries, however, have just decided no longer are we going to respect this. Particularly countries, you see countries resisting the notion that you can have people selling advertising, let's say, in your jurisdiction, but no data infrastructure. So Brazil is the worst offender in this area, by the way. The Brazilian prosecutors will grab anybody. I remember a case when during my Google days when the content at issue was child sex abuse imagery, the worst stuff on the internet, right? And they were investigating it in Brazil. It had been posted on Orkut, which was a social network that Google ran, but from servers outside Brazil. None of it touched Brazil. There's a federal statute in the US relating to that kind of content, which specifies that it must be turned over to the FBI and the National Center for Missing and Exploited Children only. There's no room in the law to turn that over to anybody else or any other country. So Google's answer was, well, use the MLAT, contact the Justice Department through the State Department, and then work together as law enforcement, and then we can turn it over lawfully, because otherwise we commit a crime in the US. And the Brazilians did not react well to that. So they arrested at least one Google executive and used the presence of salespeople, different part of the company, different, whatever, but to get their hands on data which was not stored inside Brazil. So the more extreme versions of this these days are countries that are saying we are going to require that all data relating to our citizens be kept inside our borders in order for us to be able to control it and to not have to resort to these dodges or depend on company cooperation to get our hands on it. So that's the big trend. Let me just mention what I think is the interesting long-term trend here, which is as a sort of a puzzle. So most of these kinds of moves depend upon the current state of this endless pendulum in computing. So we've gone from the core to the edge to the core, and now maybe back to the edge. And what's interesting is, and what I mean by that is we've gone from powerful mainframe computers with dumb terminals, which was what I got on in the 80s when I got on the internet, to PCs that were very powerful because Moore's Law was putting so much processing power into computers that they started to be able to do amazing things that you didn't need a mainframe for. Then with the network, we saw the concentration of computing power in these huge data centers, which we call the cloud broadly. But this is a relatively dumb device, my iPad, but because it's got a link to the Google data center infrastructure, I can do staggeringly powerful things from here with very little computing power. And so what I think is interesting is we're now seeing, thanks to Moore's Law, and this is the cool variable, quantum computing, the potential for massive amounts of computing power to live here. So one of the things which we're all obsessed with is what's happening to national governments' efforts to control the internet using these core infrastructures like data centers, where the data is held and the big companies that control it. I think within a few years, it won't be this year, won't be in the next 12 months, but I think within a few years, this thing will be able to basically hold all that a Google data center held a couple years ago. And when that's the case, we will see a return to the peer-to-peer infrastructures of communication and publishing even that will disrupt this whole conversation and frustrate US and other law enforcement again. So one other little footnote about that, which is that one of the things which people are very excited about right now is called the blockchain. So the blockchain is basically an applied use of cryptography. So the same encryption that we use for SSL connections or HTTPS, that same encryption, which basically depends upon one-way mathematical transformations, which are very hard to go back on. The blockchain is awesome because lots of people are looking at it and saying, here's a way that in public you can document transactions that you can't undo. So if I, buy something, it can be documented. In public, the world can verify that, and we can't work our way backwards. All of that just depends upon a certain ratio of computing power that exists right now. I think that quantum computing, if it is advancing as fast as I think it is going to blitz through not just the blockchain, at least until we can re-architect cryptography to use that power, but also things like HTTPS and SSL and these other security protocols, which we now depend on. Hugely interesting. Finally, let me just say that the big story in surveillance, so this is the other great axis of conflict online, the other big story is this incredible wave of arbitrary arrests and detentions that we see around the world, the killing of secular bloggers in Pakistan, and what's really come to a head outside of the kind of peculiarities of the Apple FBI debate is that we see increasingly these third-party networks. So these are the tech companies that host the communications and speech that's going on in the world in this weird, model that I outlined earlier, novel model. And where I think the tech companies are going to have the biggest challenge, and where I think the biggest push from sophisticated law enforcement agencies like the FBI that are trying to provoke a crisis here that they can use to spark legislation, is that a lot of conversations that are taking place across jurisdictions are happening online in spaces that are somewhere between public and private. So they're not the private communications like WhatsApp. They're not the public acts like tweeting or blogging, but in these kind of like group chat environments. And the only player that has the ability to monitor what's happening in those spaces is the tech company hosting it. And I think it's interesting that these tech companies clearly can monitor for ad targeting. They can monitor of certain kinds of communications. They have the ability to look for child sex abuse imagery, which many of them do. They now use a database out of the UK to test images to compare images being sent to each other. And it is not unimaginable to me that a case could come around where a tech company would be in a position to use natural language processing and AI, not to turn communications over to law enforcement, but just to surface it for human review in the same way that they do with child sex abuse imagery or other kinds of currently disfavored communications, such that these spaces could then be made vulnerable to tech company surveillance, which, as we all know, is a proxy for law enforcement where it exists. So anyway, those are my views. I think there's lots of other stuff to talk about, but I should shut up.
Well, I was going to say, if we were playing some kind of drinking game there, Andrew, you got through the blockchain, AI, cloud computing, kind of it would be...
buzzwords too. Yeah.
Exactly, and there was a certain amount of European bristling around me at some of the suggestion that companies are good and governments are bad. So, Bertrand, it's a good time to turn to you on this.
Stand over there. Yeah, I don't have slides, but it's better to see people. So, you know the saying that when you have a hammer, everything looks like a nail. So I run a project called Internet and Jurisdiction, and of course, if you ask me about the trends, it's all about jurisdictions. The second thing is, among the things that have been discussed, I want to highlight that we're confronted with two very delicate balancing problems. The first one is, given the cross-border nature technically of the internet, we have to preserve this global nature of the internet and the services that run on it, but at the same time enable the application of national laws, because one after the other, every single country has reaffirmed the applicability of national laws. So this is the first tension. And the second tension that we tend sometimes to forget is that as citizens, we want that the misuses and abuses of the internet are being fought, and at the same time, we want that it is being done while preserving and even fostering human rights and protections. And it is not an easy conundrum. So I want to highlight three things, because being French, everything goes into three things. We're trained that way. The first one is what I label usually as the legal arms race around the concept of territoriality in interpretation of jurisdiction. The second thing is the whole issue of responsibility of intermediaries, which is growing tremendously. And the third element is the aspiration, I would say, towards finding references, principles, frameworks, and mechanisms to solve those transnational issues. So rapidly, on the legal arms race, and I would echo a little bit what Andrew was saying, we do have an international legal system that is fundamentally based on territoriality of jurisdictions. This is not new. It's a very Westphalian concept. The problem is that with the internet, we have a lot of potential territorial hooks. It's the location of the user, it's the location of incorporation of the company, it's the location of the server, it's the location of whatever you may think. And at the moment, because there is no international framework to solve most of those issues, what the governments are doing is to try to leverage the traditional tools. And those traditional tools lead to this objective extraterritorial extension of sovereignty. And so, without going into details, you know most of them, I want to highlight just as a word 4 cases. The first one is Microsoft and the Irish data server, the access to a Hotmail account, which basically, if upheld by the US courts, would mean that the US government would have access to any data, irrespective of where it's stored, on any person, anywhere in the world, as long as it is an American company, which is an extreme extraterritorial exercise of sovereignty. The second one is, of course, the right to be de-indexed. And I know how vehement most of my American friends are regarding the right to be de-indexed, because it's extremely unpleasant to see the reverse and the boomerang effect of the kind of legal attitude that a lot of Americans have had towards the rest of the world, in considering that their legal system is so much better that it should be applied worldwide, which was basically everything that was done through the terms of service in the past. You are anywhere in the world, you tick the box terms of service, bingo, you are under US law. And with the right to be forgotten or right to be de-indexed, whatever we may think about it, we're in a situation where the boomerang is coming the other way around. Yeah. That being said, it's an extremely delicate case. And I want to highlight one thing, which is that the reasoning of the CNIL that a few people are mentioning is not the desire to be extraterritorial as a matter of principle, is that the argument is there is one single processing, and if this single processing worldwide violates European law, it should be cancelled. I can tell you that this is an extremely seducing argument for a lot of governments and a lot of actors. And it will be very difficult. I'm sure that the Conseil d'État in due time will be confronted with having to solve this issue, and it's a very tricky one. So those are two very important legal competition and legal arms race. But there are two other cases that you're maybe less familiar with. The first one is the data protection regulation in Europe is establishing extraterritorial sovereignty. The moment that you serve citizens and users in Europe, you are under the data protection regulation that has just been adopted. And more importantly, I don't know who's familiar with if you're familiar with the Yahoo case in Belgium. The prosecutor in Belgium, who was participating in a meeting that I attended in Amsterdam a couple of weeks ago, made an amazingly strong case. He's gone 3 times to the Cour de Cassation in Belgium. So appeal, Cour de Cassation, back to appeal, back to Cour de Cassation, back to appeal, back to Cour de Cassation. He's been very persistent. And his reasoning is the following. As long as you are serving citizens in my country, I do not need an MLAT. You have to obey a production order that I do at a national level. And I can tell you that this, again, is an argument that resonated very, very strongly with a lot of the people in the audience who were prosecutors, because everybody's frustrated with the MLAT problem. And so the question of the mechanisms for content takedown or extraterritorial extension of sovereignty is also related, and I will not elaborate, on the question of the reform of the MLAT system and all the elements of investigation, because today, every single investigation requires access to digital evidence, and when the digital evidence is abroad in an American company, there are no clear and simple rules to function with that. So that's the first point. The second point, quickly, is the question of responsibility of intermediaries. You know that fundamentally the regime has been a regime of non-liability of intermediaries, mostly based on the fact that early intermediaries were mostly hosting companies with absolutely no involvement in the management of the content. So you had a sort of spectrum where at the one hand you have pure hosting companies, at the other one you have news companies, and in between there is this whole range of platforms that have emerged that do have an element of implementation of their own terms of service, and Rebecca is absolutely right. There is an element, a normative element in the definition of the terms of service of the companies. And I was very, very interested in one of the sessions yesterday by the expression, the concept of norm entrepreneurs. The companies are, through the terms of service, developing a certain number of rules that de facto represent the law of the online spaces. In the context of terrorism and in the context in Europe of migrations with all the tensions between the different communities, those companies are under intense pressure by the governments to basically play the role of policing their own spaces and go as far as being under pressure to do some sort of active monitoring. And if you want to examine the Delphi case in a very extensive interpretation, this is going in this direction, and that was mentioned just before. If the companies have all the tools to do the screening for advertisement, they should be able, of course, to have a screening to identify the terrorists, which, by the way, is an argument that is a little bit fallacious, because you can accept false positives for advertisements, but a lot of false positives for you are a terrorist is a little bit more tricky. So the thinking that basically because search engines are so powerful in indexing billions of files, they should be able to provide some sort of app whereby the law enforcement would get out of his lunch and say, okay, where is the nearest terrorist that I can arrest tomorrow? Makes no sense. And unfortunately, there's a sort of confusion in that regard. So the question is that at the moment, there's this pressure towards potential active monitoring. There's the fact that de facto, there is a sort of delegation to the companies that are placed in a situation of exercising quasi-judiciary functions. They have to make more and more decisions on direct requests that are being sent by public authorities in one country towards the companies in another country regarding content that is legal in one country, illegal in another one. And the pressure has been growing, particularly in countries such as Germany and France. And what is interesting is that the large companies and the large countries, mainly in Europe, have developed a certain number of procedures so that some rules have emerged. But those mechanisms are relatively opaque and they are not scalable easily to the other countries. Like, it is not easily implementable for smaller platforms who do not have, let's be honest, the resources, human and financial, to handle the huge amount of requests that are going to fall on them. And second, it is not easily applicable to smaller countries, especially because some of those companies receive requests that come from a Yahoo Mail account, and it's actually the law enforcement of Kenya. I take Kenya not as a particular example, but so having appropriate procedures that make those processes more respectful of a transnational due process is one of the biggest challenges that we're confronted with. And in the program that we run, that fortunately those large companies and a certain number of governments are participating in, we sense, and that's the third element that I want to highlight, an appetite for more predictability, more clarity about the procedures and that sort of thing. So the third element, and just to finish on the intermediary responsibility, the Council of Europe has set up a working group of 13 people, and Dirk Verhoef and myself are members of this working group that will work during 2 years on the question of intermediary responsibility, and it's going to be an interesting work. The other element is that, as we were discussing in the right to be de-indexed, one of the big challenge will be to find escalation paths for appeals if we accept the notion that the companies, in many cases, for issues of scalability, will be making the decision in the first instance. So how do you go to review the decisions of the company, knowing that appeal mechanism on a trans-border basis is not an easy issue? So final point, the appetite for transnational references, frameworks, and so on. I think everybody is scrambling for solutions at the moment, and everybody understands that if we use the traditional tools, and territoriality was a perfect example, if we use the traditional tools and we pull them to their extreme application, we get into absurd situations. And not only absurd situations, but the potential for conflicting laws and conflicting norms, as we discussed, is only going to increase. And for those of you who are familiar with game theory, in Prisoner's Dilemma, if you don't communicate, it's obvious that the solution is suboptimal. And this is what is happening today. Everybody is trying on its own to find the solution, and the likelihood that this is the optimal solution is almost nil. So it is necessary to bring people together. And in that regard, I want to highlight the fact that, one, everybody is looking at international jurisprudence at the moment. And the work that is being done here in the group by Agnès in documenting jurisprudence is extremely important because everybody is looking at everybody else. And if you allow me one anecdote, one of the best programs on TV, you will find it strange, but one of the best programs on TV that I've ever seen is at 3 o'clock in the morning, jet-lagged in New York, seeing on C-SPAN a dialogue organized between Scalia and Breuer on the issue, should a Supreme Court justice, in a dissenting opinion, explicitly quote the jurisprudence of a foreign court. And it was fireworks, and of course Scalia was absolutely opposed to any mention of a foreign court. I see the trend in more and more courts to try to find international references. And in that regard, the companies are also norm makers. They can embed in their terms of service elements of convergence. And if you look at the terms of service of most companies, you can see in the last 5 years elements of convergence in wording regarding what is acceptable and what is not. And I think there is an aspiration for a certain number of emerging norms. I would give you very quickly the headlines of a few. One is what has perspired in some of the cases that were mentioned. There is an emerging norm that it is not proportionate to block an entire platform because of one piece of content. There have been decisions now in Turkey, in Pakistan, in Europe. This is an emerging norm, and we need to document it. The second one that is probably less familiar for people in this room is things that are related to the domain name system. There needs to be a documenting of the norm that the domain name system is a neutral layer and that any action at that level is only justified if there is a harm that is sufficiently global to justify that the action has a global impact. The next one is the notion that today there is a transnational impact, potentially, a transborder impact of national decisions. That's the Microsoft case, that's a lot of things. Governments should exercise their sovereignty with a level of responsibility in the digital age that takes into account the potential transborder impact of their national decisions. And finally, I find fascinating in terms of emerging norms how quickly the question of revenge porn, or what we should probably label more as non-consensual posting of pornographic material, has changed in 2 years from a relatively obscure topic to a now globally accepted norm that it is absolutely unacceptable and so on. And here, I think some of the companies, and that includes Google and others, have triggered the catalytic effect of a global norm by deciding that they would embed it in their terms of service, that then California has adopted a law like this, and I think this is going to spread globally as an international norm. So I finish by saying there is a need, and that's what we're trying to do, to bring the different actors together around specific issues, to develop transnational frameworks. There will be no possibility of developing treaties on most of those issues. It's lengthy. The terms of service or the platform decisions are one very important thing, but it remains an internal process and it has to be more collaborative. And so, therefore, in an environment where the transnational dimension is increasing, more and more things are becoming across borders. We need the spaces to have those discussions and to bring together the norm entrepreneurs to define shared procedures. And due process across borders is probably one of the rallying cries that we can put forward.
Excellent. Thank you. Thank you very much indeed, Bertrand. Ross, you've been talked about a lot on this panel. It's your turn now.
Thanks very much. I knew I was going to be later on in the program, so I came to the panel with a laundry list of both issues that we've seen in the past year as well as things that I expect we'll see in the coming year. Many of them, I wasn't disappointed at all by my fellow panelists. They raised a lot of the issues that I have on my list. But there are some thoughts that I'd like to add to some of the topics, and then one or two that I wanted to add altogether. There's no doubt, obviously, there's no doubt that encryption is very much on everyone's mind at the moment. The Apple case for me was fairly striking. You'll recall that the FBI said that this was a one-time deal, and then the ACLU came out with a really interesting study that showed that far from that fact, it had been requested of companies dozens of times that companies provide keys to their own encryption, which we weren't even able to provide. What also was very striking to me, of course, is that I couldn't understand, and this is more of a personal view, I couldn't understand why what the FBI was asking of Apple wasn't somehow a government taking or a government forced labor project, to the idea that they would mandate that Apple engineers build a product that does not exist to break into Apple's own encryption was just was astounding to me, and that's a personal view I want to emphasize. You know, there's no doubt that encryption is fundamental to the exercise of human rights and free expression. David Kay, I think, got it exactly right. But, you know, it's also fundamental to fighting crime. You look at the issue of identity theft, just in the US alone, $100 billion, I think, last year, 47% increase in 1 year in the incidence of that. And human rights are important, but, you know, I think about a working mother trying to raise 2 kids, having her identity stolen, how devastating that is to her life. And the idea that we shouldn't be allowed to provide encryption to protect her identity is just ridiculous to me when you see the incidence of identity theft. Definitely the role of intermediaries. A lot has been said about that. You know, I agree. I think I want to emphasize that the companies that are, of course, most vulnerable when put in the place of responding to government requests and demands, of course, are not companies like Google, where we do have the resources and do fight back all the time. I mean, if the number of lawyers and policy professionals that are engaged full time in these negotiations and lawsuits and countersuits is pretty astounding, I think, to most people. It's really the small local players that are most at risk, who just simply can't fight back, you know. And then you think about the role of, you know, the impact on innovation and entrepreneurship. And, you know, how is a company supposed to get off the ground and provide new interesting products to the world when, you know, they can literally be buried by government requests and driven into the ground and go out of existence because of how expensive and time-consuming those things are. You know, definitely we've seen a rise in surveillance laws. I think it was 14 countries that we know of in about the past year have passed new surveillance law. But what I also find interesting is the increasing sophistication of surveillance and censorship technologies. You look at China in 2010 and before, what the Great Firewall was. There was a reason why they put companies and intermediaries on the front line. It's because they couldn't match our technical prowess. And the sophistication of the Great Firewall now is leap years ahead of where it was back then. You know, it is really powerful, and it does a very good job. You know, in essence, I agree with Bertrand, of course, that, you know, what we're dealing with here is basically a conflict between the Westphalian notion of jurisdiction and what the internet really is, right? China is doing a very good job rebuilding a Westphalian view of jurisdiction and building its own internet. A recent proposal from China about requiring all sites to be registered with China alone. I mean, that's a very clear movement, I think, in that direction that we need to be following, and we're trying to figure out the best way of engaging there. Right to be forgotten, of course, or right to be de-indexed, I believe, Bertrand, did I get that right? Yeah, I just want to be sure. Yeah, you know, horrible development as far as I'm concerned. You would not be surprised to hear that for so many reasons. So many reasons. A vague ruling putting companies in the position of trying to balance, is public interest best served by leaving this up or by taking it down? Unilateral appeals process where only the requester has the right to appeal to the local DPA, but the underlying site, we're not even supposed to let them know that content has been taken down. It's ridiculous, really, you know? So that's a real problem. And then that's even before we get to what I would still call the extraterritorial application of French jurisdiction to the global internet. Extremism, radicalization online. Honestly, I'm mostly concerned about this because it's an excuse that governments are often using for censorship and takedown requests. There is a problem, of course, of using online platforms to radicalize youth. The real radicalization happens offline, of course. They may make initial contact online. They quickly move either to the dark web, or they say, let's go have a coffee 3 blocks down the street. Radicalization itself does not happen offline, but when you talk to most governments, they insist that it does, and it's quickly followed by demands for taking this down and building this tool and cooperating with us. in greater sense. There is a somewhat spark of hope in this issue, though, which is increasingly governments are recognizing that counter speech is an important part of addressing this issue. I don't know if they fully realize it, but when they embrace counter speech, including the French Justice Ministry, I'll say, when they embrace counter speech, they're basically embracing a multi-stakeholder approach to internet policy. They're saying, we don't have all the answers. We can't solve this through censorship. We need civil society and other actors to come in and help us out. And they're also making basically a free expression argument, that the answer to this speech is not taking it down because as soon as you do, 5 more sites come up. They're saying that the answer to this speech is more speech. And I think that there are ways that I'm thinking about of trying to build on that. Data localization, obviously, has already been mentioned. I want to talk about 2 other things quickly that haven't been mentioned, which is, the first is internet governance. I think it's now no longer the hot topic it once was, but it's very easy to forget that in the end of 2012, there was a very real and present risk that not only were we going to be dealing with individual challenges in each of these countries and free expression and how the internet was run, but they were quickly turning to multinational organizations like the ITU to try and build a consensus around this work. And I'm actually thinking at this point that we've done a fairly good job at beating that back. There was the Wicket in Dubai in December of 12. Then there was the Busan meeting of the ITU and shortly thereafter. And in December of last year, 10 years after WSIS, the UN said, no, no, the correct way of making internet policy is the multi-stakeholder approach. And they beat back plenty, I think it was over 100, very problematic proposals from the usual suspects, China, Russia, and some others, to say we are not going to be the place where that sort of work is done. Doesn't in any way mean that, our battle, the battles are over, because as my fellow panelists and I are talking about, we're still waging wars country by country and jurisdiction by jurisdiction. But I did want to take a moment to at least acknowledge that there's been some success on that. The final thing I wanted to mention is this new, relatively new issue, which is ad blocking, which you may not think of immediately as a free expression issue, but I do. There have been plenty of apps online where individual users can say, you know what, I really don't want advertising in my internet experience. I'm going to deploy this ad blocker. That's fine. What we're now seeing is ad blocking at a network level. Digicel has used this thing from Shine Technologies. I think that's a real problem, because whether or not you like ads, and there's plenty of room for improvement in that, ads is a commercial form of speech, and ads, when used appropriately, can be very informative. But what's even more problematic is when you look at the net as it's currently designed and used. A lot of free content is there because it's paid for by advertising. And the people who are really going to suffer in a world where there's network blocking of advertising are independent bloggers who make their living through advertising, independent journalists who, again, do the same thing. And I also think about the impact that this is going to have on new writers and creators and journalists and new entrepreneurs and platforms. Without advertising, they're in real danger of not being in existence anymore. And I think we should be paying attention to that issue. And I think that was a long sort of list of things that are on my mind. I'll now turn it over to Mishi.
Thanks very much indeed, Ross. I like the appeal to the chair with the important thing is the health of the state of journalism. Always good to hear. Mishi.
That remote.
Over there, behind the Seagrams.
Oh, sorry, yes. There we go, yeah.
Well, I'm speaking at the end of 2 days. Everybody has taken all the trends already. I'm going to make some trends of my own now. So, in the very beginning, how many of you use encryption? And how many of you shop online? So all of you are using encryption. And because the news stories are writing these speeches for us already, as lawyers, we owe it to ourselves as well as clients to encrypt all our communication and make it difficult for everyone else, because math does not recognize bad guys and good guys. Math just says it works this way, and that's how encryption works, and which is important. So that point everybody has made. I'm going to say few things about the trends. But before that, I'm going to make some comments, some principles, not trite, not about the same thing about how great internet is, but just important to lay them out at the very beginning so that you know where I'm coming from. The first thing I want to say is the integrity of the network that we call internet, that it provides one indivisible opportunity for everyone connected to it, is its most important feature. As a tool of social development, it allows people with little capital equipment, but plenty of ingenuity to build effective businesses from zero. And it's not a basket of media websites which we consume as any more than a highway is a collection of stores along the side of the road that we shop at. It is the possibility of unlimited interconnection, a social condition in which we can all be connected with everyone else everywhere, and that allow us to produce services for one another. The second thing what I want to say is what happens in the US or Europe has a large impact on the international policy making, wherever you are staying. Having said that, not having Russia, China, Iran in the discussion does not help any of us, because there is a big part of the world population in those countries. And the third one is that issues of free speech, privacy, phone fetishizing, or economy, or crypto wars and access, they're intertwined and can no longer be discussed in these silos. Now, that's out of the way. I'm going to say about 4 major trends. The first trend is like, hey, Siri, or hey, Google, can you solve all these problems for me? And that's the trend. Expectation from companies to solve these very complicated issues, from whether it's the users or it's the governments, saying, can you help us balance free speech and expression? Also just take care of the propaganda issues and the censorship one. Can you also do privacy and surveillance and solve some criminal problems for us? So why don't you do everything? Also, because you guys are disrupting so many traditional models, you owe it to all of us to actually undo your business model and help us. It is a trend increasing, see it many times. Small players, big players suffer differently, but it is a trend. The second one, why this slide is up, I'm very lazy. I just use other people's slides, and I'll do the copyright notices because this is all fair use. It's not my picture, but this is a picture of a protest in India about free basics by Facebook. So internet connectivity. The trend is that the other half of the human race is getting the internet. And the arrangements under which they do that, the forms of public-private partnerships, in effect will determine the extent to which the free speech is put in private hands. There are 2 elements that fall out of that cardinal fact. One is the increasing importance of the regulatory structures of the government over the parties providing these networks, whether it's their own telecommunication service providers or data miners. Second is the recognition that what might have been thought of as traditionally public speaking, this expression in the public sphere, is actually going on inside the hands of private companies, which means just that the built environment around the human speech has now changed, and how it affects on free speech is a big issue. This question is rather like the one which was faced by the US Supreme Court over company towns and shopping centers and other forms of private location, has a long history of First Amendment law, but nothing about the American legal results will be copied anywhere else in the world. But the conceptual problem, what do we do when what we think of as public expressive conduct is conducted under the governance of private companies, is becoming the sub-question in the large question. This public-private responsibility division is having significant legal consequences as well as political and social consequences everywhere. it has also led to very interesting conversations such as digital colonialism, where people in the global south are saying, hey, Sandhill Road, don't tell us what we need or how should we have our internet. We can do that on our own. The second trend, the third, I think, illiberalism is rising everywhere. You have so many of these great leaders we've all heard about, and either some people have thanked them or recognized them for all the various problems they are creating. They are telling us what insult is, what criticism is, and what we should be punished for and not for. But illiberalism with respect to the expression in the net is gaining ground in so many parts of the world simultaneously. And this movement towards illiberal democracy, again, Turkey, Russia, some parts in India, for that matter, the fixed illiberalism of the Communist Party of China now embraces a substantial part of the world's population. And the most important question we face is our understanding of free speech in the net an artifact of liberal democracies? The conflict between a theory of universal human rights and the reality is now in the net. It's very clearly seen in the difference between when European Code of Human Rights approach to comprehensive surveillance in Russia and then what Russia does and its approach to the European Code of Human Rights. Then it's apparent in this animosity between the idea of whether Indians, over 1 billion people, have the right to privacy or not, on one hand, and the rapid pace by which a universal identification Aadhaar bill is passed through the parliament. It's, of course, a fixed fact that the European government's hostility to Google, Amazon, Facebook, and its own absence of innovation in this area. What also has been happening since 2014 is that the leaders have realized that electoral politics in all of the world democracies have moved to Twitterverse and social media space. They have, and that has led to even more aggressive attempt to control the net in the Russo-Chinese style. Everybody understands now, even in democracies, that winning elections depends upon shaping opinion through social media. And a whole series of democratic leaders, I'm not going to name them here, we all have already heard about them, have now beginning to understand that if they let the forces that they have traditionally used to discipline opinions out of the box, they're going to be willing to control the net completely. And this has led to many incidents of internet shutdowns, and everywhere. We've seen in 2015, 5 states in India faced internet shutdowns over beef-related violence. In February of 2016, people of Uganda, as they headed to the polls for a presidential election, the government cut off, again, the internet services, including social media websites, for 4 days, purportedly to say due to a threat of public order and safety. January 2016, again, Etisalat shuts down access to internet completely, no free basics. I have different views about how effective their encryption is, but still no free basics. But what is happening is a complete blackout and becoming a common practice during elections or any other time when there is some problem coming here. So illiberalism is on the rise throughout the human race. And now I'm going to say something which I'm sure nobody agrees, other than the Americans. First Amendment is the binary answer, is the answer in the binary form. Now, most of the world's online population's data does rest with American companies. Let's just recognize one thing, that all discussion about global privacy rights and global free expression must begin from the recognition that American First Amendment is the incumbent structure. And working alternative right now seems to be illiberalism. And in our view, from where we come from, it sees European position is economically and politically incoherent here. The fourth trend is these procedures of totalitarianism. They are being fastened on the human race everywhere. Sometimes in the name of convenience, the other times to tackle terrorism, a very grave problem, but often used as a blanket excuse to rein in all sorts of civil liberties. Me watch you, you watch it. Telecommunications service providers being used to monitor and scrutinize behavior of the customers and the governments. seeking social graphs of their societies. Yeah. The government seeking social graphs of their societies for the purpose of perfection of social control, which means better subsidy payments, better social welfare programs, but which inevitably also means more effective tyranny and increasingly inescapable prison for all of us. Bluffdale, Utah, where Big Brother and Big Love have become uneasy neighbors, is the US government's way of doing it. The Chinese government has this universal reputation score, which is tied to every person in the country's national ID number. It's based on factors such as political compliance, hobbies, shopping, and whether you play video games or not. And then you get, it's administered by Tencent and Alibaba, and scores are generated not only by your activities, but also by your friends' activities in the social graphs. So negative points for mentioning Tiananmen Square and speculating on official corruption. No, many negative points. And also from things from which the state wishes to nudge you away, like don't play too many video games, otherwise the score goes down. Now, Aadhaar, this biometric identification system for public, for delivery of distribution services, but building a centralized database tied with your iris scans and your fingerprints. Now, the Apple versus FBI saga seemed, this is not mine, you can see, again, it's a thing which someone described, I think, very aptly, and that's how it actually went. So we see, now we are all here as civil society people, and we are now dependent on private companies like WhatsApp suddenly decides to give us end-to-end encryption, and Apple decides to become the savior of our privacy. And then also the government's trying to talk to the private people, and we also don't understand exactly who do we approach in various of these issues. I have no answers, I just keep raising questions. Also, being lazy, I use last year's slide because right to be forgotten, that ridiculous thing, is still on and has told many people in different jurisdictions that you can have such a thing and rewrite history. At least in India, thankfully, intermediary liability no longer works that way. And our court could actually tell us you need a court order if you want something removed or an order from the government agencies. What to watch out for? Maybe we will still be using these slides again, which will be very unfortunate. But I don't think that 12 months is a long enough period to solve the problems. But Brazil, we all looked up for Marco Civil the Great, is already in danger of it. All through the global south, there is an attempt to vertically integrate world's communication systems by all these, by convergence and also offering connections and free internet, which is only an attempt to buy de-anonymized packets of the poor and calling it charity. Right to privacy in India. The crypto wars, once again, where we are going to make new mathematics. And, but very important issue also about online harassment, which, yes, more speech or more issues and various ways have been discussed. I wasn't asked to give any answers, so I'm only laying out what I see. So that's about it.
Mishi, thank you very much indeed. And thanks to all the panellists. There was an awful lot to go at there. I hope that the person who drafted The Right to be Forgotten was not listening in, because they got quite a rough ride. But apart from that, if anyone has questions, we have about 10, 15 minutes. There's a question here.
Can I ask a question of Bertrand?
Yeah, sure.
So here's what I think is
happened. Yeah.
But so here's what I think is interesting. So I've been following your project, and you're kind of like a stand-in for a broadly European sensibility about the value of vindicating national jurisdiction. You mentioned it before, that's one of the things we have to do is allow countries to enforce their laws. And then I think Mishi did a really good job, though, of pointing out that two things strike people like me as problematic with that. And that's why we have clung to the internet as a steamroller that can flatten national jurisdiction and ignore it widely. And those two things are, one, the universality of human rights. So in other words, the value of freedom of expression, regardless of the nature of the system that is violating it, is one that we think is so universal that it can and should be embedded in the very architecture of the internet, and that should be defended against efforts, even by liberal democracies, to violate that principle. The second one is that many of the states in question, let's leave aside the totalitarian regimes, right? Let's leave aside China, let's leave aside Turkmenistan and so forth. But let's focus on the many countries which have some incomplete, weak, or unreliable rule of law. So I would include India, I would include Brazil, I would include Turkey. They're beset with corruption. They have systems where individuals are much more powerful than the institutions themselves. So for those two reasons, I have long been sympathetic to the idea that actually national jurisdiction is actively to be disrespected in many cases, and that the beauty of the internet is that it does precisely that. Are you moved by that? I mean,
I think it is not up to me to take the place of all the different courts that one after another have established that the national laws apply. And so you're absolutely right in saying that initially the cross-border nature of the technical architecture allowed to, and I take your word, to steamroll past jurisdiction. But in doing so, it steamrolled imposing one jurisdiction among others. Because the reality is that we have benefited from this globally unified internet because it was mostly under US law, because of the terms of service and because of most of the contracts that were there. And the reason why we have a problem today is because we have to reconcile, and this is the aim of my formulation, we have to reconcile this desire to keep what we, in the project, the Internet and Jurisdiction Project, call the global accessibility by default on the internet, with the fact that every single country, one after the other, is reaffirming the applicability of national law, which is the foundation of the international system. So I want to make an analogy here. We have a Westphalian system that is based on the territoriality of law. When you change paradigms, you don't necessarily discard everything. And in the case of the application of territoriality, if I make an analogy with physics, if I throw this pen right now, I can still use Newtonian physics. There's no problem. It was created in the 18th century. It still works. You can build bridges. You can do a lot of things. If I throw it fast enough to get into light speed, I need relativity. And if I want to have the internal structure, I need quantum physics. Each of them has a zone of viability. If there's a Frenchman insulting another Frenchman on a French platform, and they're both living in France, in French, I'm sorry, it's the French law, period. The moment it's a French guy traveling into Los Angeles insulting an Argentinian, when you get into a more fuzzy environment. And the challenge we have is how we reconcile those things. And I want to highlight one trend that I didn't mention, which is the adoption of geo-IP filtering in a very strong way. And the Google case on right to be de-indexed is the latest installment. Excuse me, this was introduced mainly by the intellectual property community in the US to make sure that the Hulu and all the others are not accessible in Europe. So talk to me about refragmentation of the internet.
I think that's a no from Bertrand.
The only thing I want to say is rule of law is robust and kicking in.
Okay, I'm trying to assert sort of like a different rule of law here that says that you guys should be able to ask questions. So we go there, yeah. Sorry, we've got the microphone, thanks.
It's rather a comment than a question, and I have to say, as a European, I feel sorry, but I have to back Bertrand because I do understand that there exist countries in the world where internet is blocked, where procedural rights don't exist, where the legal standard is quite low, but you have to see that states and with the states, the citizens in those states living there under those legal frameworks do have a legitimate right to have access to law enforcement mechanisms which they are used in their countries. I give you examples. Facebook is for goodwill, it's not obliged. It complies with law or works together with law enforcement agencies or forces in Europe or European countries when it comes to suicidal cases. If the police forces get information that there might be a suicidal case and they need to have access to that person, but the information they can only obtain through Facebook. If you would say, as has been said on this panel, that they should go through US law enforcement mechanisms or US judges, that would take, because that's a diplomatic thing, you have to go through the embassies, that would take months or weeks, at least 5 to 6 weeks. That would be too late. Also, that's very true for cases where law enforcement law enforcement agencies do have to have access immediately because it's someone has been taken hostage or stuff like this. Yeah, these are issues we have not dealt with on this panel. I do see the danger, and it's for good reason that there are very strict regimes in the world. Another issue is maybe the legal standard in those countries which do want to apply their laws are higher, concerning, for example, procedural rights of the persons who have been surveilled, online surveillance of communication. You have to notify that person at least after the measure in some countries. As far as I know, intelligence law in the US does not provide such an obligation if it's an international person not residing in the US. So those are the reasons why some states are so lunatic, and some Europeans are so lunatic to say, okay, we are old Europe, we want to stick to Westphalian laws, yeah, or the idea of Westphalia. I'm sorry to say that, but these are the reasons why...
Can I just ask Mark to come back on that? 'Cause he was...
Yeah, I mean, I'm rather pleased that Bertrand's taken on the role of the whipping boy for Europe, but I just, well done, stepping up. But I would like to just say, I have real problems with this privacy notion. We have a notion of privacy in Europe. Most of us from the common law bit of England and Ireland don't want it. We don't, you know, for example, our cousins in Australia and New Zealand don't have it. But we used to have a principle in international law of double actionability. It had to be an offence in one country and an offence in another country. We don't have that. You don't have privacy in America. We have it in Europe, but it's not there. So we've driven a coach and horses through the double actionability rule, which I think is really, really worrying. And also, while we're at it, we're driving a coach and horses through corporate structures. Because, of course, if you think back to the Costella case itself, you know, that was a Spanish ad sales company which was wholly owned subsidiary of an Irish company, which was a wholly owned subsidiary of a Californian company. So how is it that you can execute a judgment against a triple subsidiary who doesn't have control over everything? That seems to me to be where the judiciary have gone completely bonkers.
Okay, that's fine. I've got. So you had your hands up first, and then I'll come over there, and then Agnes was. Yeah, can you use the table mic? Hopefully.
Is it working? Yeah. No, so it's not a question. It's just a remark about what's been said about the CNIL case again. It's not my point to defend the CNIL. As I said, the Conseil d'État will be confronted with the subject in a few months ahead. So it's my duty not to have an opinion at this stage. We'll see when I have the files in my hands. I just wanted to underline that I really don't believe that it is sort of some moral hubris that led the CNIL to take the sanction against Google. The CNIL has a duty to enforce a regulation which happens to be the transposition of a directive, European directive. which grants the individuals with a subjective right to protect their private life and to be de-indexed whenever their private life is at stake, provided, of course, that the public interest that the information is made public is not more important than the respect of the private life. And what the CNIL tried to do, I'm not saying the solution is the good one. It's very complicated. I'm not even saying that the text is good. It's not my business to say that. But what the CNIL tried to do is just finding a solution to implement that right correctly, because if you de-indexed a person only in a French website or only in Europe, the right of the person to have its private life protected regarding potential friends or professional relations that live in the United States or anywhere in the world, it's not implemented. So again, I'm not taking a cause for the CNIL or against the CNIL, but I really don't believe that it is comparable to China trying to impose some sort of...
Sorry, we have to join this argument, though, because the ruling is clearly, it is not a censorship ruling in one sense, which is it does not remove the underlying information.
No, it's not.
It is a bizarre vendetta against a company that the CNIL has had headaches with for a long time because of its ideological view about a right to privacy. It is applied to the homepage of search results that list the person's name. It's not even effective control over what I think would arguably be the moral right of the individual to control the presentation of information about themselves. It's so incomplete, a Swiss cheese kind of approach to the asserted right, that you can't justify it on any basis other than vendetta. The horror of it though, is that it gives a jurisdictional justification to the Chinese to try to control what somebody in the United States can and can't say on the internet.
No, not at all.
Because the CNIL's position is, if I say something that is disfavored in its view about a French citizen, that it can order that my speech not be findable through the search engine globally. And that is a travesty.
I really don't agree. I mean, just one word. You have the right not to agree with what the CNIL say, and you have economic reasons also why Google is not really happy with this decision. So it's not all about free speech. But once again, the CNIL has a duty to apply a regulation which says something and says that the individual have the right to be de-indexed.
They have to enforce that law lawfully, and they're not. That's the problem, because they are enforcing it extraterritorially. The writ of the judges in France, your writ, extends only to the border of France. It doesn't come to England, and nor should it.
Once again, I have no right to pronounce myself right now on the solution that was adopted by the CNIL, but it's not at all some sort of imperialism, that it's not some will of the CNIL to rule the world. It's just a way, and it's written, it's really written in its decision that the only goal of the CNIL was to make the implementation of the right efficient. I'm not saying it's a right solution. I'm saying it's not a question of infringing all the human rights.
So I just want to very quickly, Rebecca, Mishi, and then
I don't have any interest in Google's commercial success whatsoever, but I would just point out, having founded a community of a global community of citizen journalists who are very, very concerned about censorship around the world, that the reaction of that community to the ruling in France was horror. And this is one of the problems, though, that we have, that when a sovereign government is carrying out its job, that is now clashing with the rights of people to whom it is not accountable and for whom it is not that government's job to care. And this is dysfunctional. But what do we do about it?
Okay, so
I have just two comments quickly. One, if I live in
Can you
America,
just stay on the mic a little bit, thanks?
if I live in America or I live in any other jurisdiction, I have a right also about access to information, which cannot be trumped by some country which has some different laws there. And that's why the right to be forgotten thing is Google. Again, a disclaimer: I've got nothing to do with Google other than Ross is sitting on my right side. But
in a benign fashion. There's nothing menacing about him.
And so, first thing is that this now Google is going to use IP location service or other geospatial signals to find out if a French person is accessing google.com, they should not see such a thing. Many illiberal democracies handle this thing by coming up with their own versions. There is Naver, there is stuff in China which is different, and Russia has different. Why doesn't Europe come up with its own search engine? And also the second thing is that why will I use a search engine which does not give me enough information or all the information? I will use VPN or any other kind of technical tool and go to google.com, which sits in California, because that gives me all information. That's not just directed at you, that's just a comment.
Okay, sorry, Kate, you've been very patient. Oh, sorry.
Oh,
I know
hi.
you want to come back, but...
So I had a question that I'm not sure I expect an answer right now, but so human rights, the human rights movement, at least in the Americas, have been working for the past 20 years to hold states liable not only for their acts but for their omissions. And in doing so, we have worked very hard to find states liable for non-state actor conduct. So my question, I guess, or something that we're working on and that I'm interested in hearing your input on is, what is the state liability, or what could be the state liability for lack of regulation of technology or terms of service or community guidelines or standards?
Bertrand, that's a good one for you to...
Well, actually, this is a very interesting, and it could be an element in the list of norms that I was talking about. Just like I mentioned the notion of responsibility of state for transborder impact of national decisions, which, by the way, I was able to help introduce in a recommendation of the Council of Europe back in 2011. This is a very important element, the responsibility of countries to provide an environment that ensures the respect of rights and fights the different misuses and abuses. Because there's an element here, and this is why I mentioned earlier, there's a second tension, which is, at the moment, the challenge is that it becomes extremely easy to take argument of the growing natural expansion of misuses and abuses that are a reality, to have a certain number of people to explain that the freedom and the cross-border nature and the openness and the general benefit of the internet obviously was a mistake. It's the whole argument about the rules of the road. Now we have developed it enough, we need very strong rules of the road. And if we don't have an effort to establish procedural norms to guarantee due process, for instance, at the international level, if we do not exercise pressure to highlight that when governments edict a certain number of procedures and norms to fight abuses and misuse on the internet, they have to respect a certain level of human rights, we're in trouble. And if I don't want to bash the members of the Freedom Online Coalition, but it is an amazing group of countries that should have one single message. Yeah. Whenever we fight misuses and abuses, our distinction is that we respect due process. And they don't say it. And I regret it, because they are the community that should be saying this. And just one brief element. On the right to be de-indexed, it is extremely interesting how passionate the arguments are, and it triggers exactly the kind of tensions that I was describing. This is a topic that is triggering and pitting legal systems one against the other, underlying principles. And we have to remember, after all, that this is not the CNIL itself. I mean, there's a decision by the European Court of Justice, which is the highest court in Europe. So whether we like it or not, it is a court decision, and it is raising very, very difficult problems on the substance of the court decision, like the interpretation of the directive, but also on the implementation today. So I think that, yes, I understand the reactions and the very visceral sentiment among a certain number of actors who are more versed in the traditional US or even UK maybe perception of how to address freedom of expression or privacy. But it is something that will not be solved by anathema on either side. I mean, if the, and I do agree that to a certain extent, there might have been in the position of the CNIL a conflation with a certain number of other cases that the CNIL may have with Google. So he didn't induce to leniency, if I may say so.
Thanks, Bertrand. Yes.
A comment more than a question. At the first panel that we had yesterday, or the second, we had a map on the right to be forgotten, and I don't know who was there. None of you were there. Maybe Mark was there. Yeah. So what you would have seen had you been there is that actually the routes, the roads for the right to be forgotten are quite multiple. Yes, there is the ECJ decision and the CNIL, but there is also a very Latin American approach to the right to be forgotten that is unrelated to the decisions by the European Court of Justice. What you would have also seen is that, remarkably, I think this is probably the only time that we can find something like this. Within a year of the ECJ decisions taken, it had traveled around the world.
Yes.
It had been picked up by courts around the world. So you can get all angry about it, and you can go after France. The right to be forgotten is reflecting a real social concern. It's reflecting civil society and people's angst over internet and over data. And your positioning does not address that angst. Okay,
Or is it maybe reflecting the concerns of political elites and those in power?
No. I'm sorry. Let me finish. You are completely. No, it's not. It's not, because what you are ignoring is as well the fact that at least for 15 years before the CNIL decisions has been taken, you have had civil society in France, Little Mothers groups, little anti-racist organizations, a number of grassroots organizations advocating around that idea that, what happened to this data? Why can't we do something about it? Why is it there forever? There is, you can try to come up with those, this theory about the political elite. There is a real social angst over internet and the data. And until and unless you guys here are taking conscious of that and are dialoguing with those people, we are not going to solve anything, and we are not going to create that new human being that the internet was supposed to bring about. Let me give you two other needs for that discussions, that dialogue. Online harassment, it's not solved. When I have meetings with organizations that are again, civil society organizations representing students that are bullied, representing women that are bullied, and I'm using bullied in or harassed in the legal sense, very grave. They do not get redress from the platform. Okay? No, that's what you think. But I'm saying that's what they think. And they think and they say it and they repeat it. They do not feel that they get enough redress, that the majority of the cases that they bring to the platform attention is not being addressed. Right or not right, I haven't checked the figures, but the reality is this is how they feel. Let's look at the porn, the revenge porn, which, well, 2 years ago, all of my friends here were taking their guns every time we were talking about taking them down. Do we know, does any one of you know, what is the percentage of underage, photos of underage people on those sites? Do you have any ideas?
What sites?
On those revenge porn sites, what is the percentage of Do we know? And we don't know because we do not speak enough with those organizations that are actually very involved in trying to bring them down. They are not censorship people. They are not representing the political elite. They are representing victims. Yeah. The people that are on those sites are victims of censorship. And you guys are picking up a definition of freedom of expression, which I am sorry, is very, male, very white, very privileged. You are forgetting that those people in those sites, the victims of online harassment, the kids who don't want their data that they posted when they were 14 to be following them all the way to their work, to their professional life, all of those people, we need to have a dialogue with them. We need to understand their concern. I'm not saying they are right, but as long as we do not understand where they are coming from, the values, the norms, the new human that we are trying to create through internet, is not going to happen.
I just have to say, human nature is a constant, not a variable as far as I'm concerned. We're not trying to change human nature. Anybody who thinks they're trying to change human nature in this is a dangerous utopian.
I should be cutting this off for time, but I'm not going to for 5 minutes because we have 3 other hands
But
up.
I want to respond to Agnes because I think there is.
Okay,
I think that the thing that clearly there needs to be a dialogue. The question is, where is that dialogue? And it seems to me that the dialogue is at the for the society, has got to be at the national level. So if there is societal angst, the response to that in the legislatures is law, and that's why the right to be forgotten has taken root in a number of different jurisdictions, as you rightly identified, and indeed other laws that you identified yesterday. But I think that what you have to understand is that there are some jurisdictions where it won't take root, because they don't share those same concerns. And so, as a consequence, we have to have it on a national, not on a regional or international basis.
And yes, that's why I said one of the big trends is about online harassment.
Can we just...
Canada Human Rights Watch. Look, I think that this is not where the discussion needs to go. I think that, first of all, child porn is illegal everywhere.
Yes.
It's not. It is one of those norms on which there's convergence, so it's a terrible example. The right to be forgotten is mostly being invoked by people who are local politicians, right? No, it's not, or it's not. It's usually not the picture-perfect example, just like child pornographers were not really main users of encryption.
But this is not true.
We have to avoid that. We have to try to look for evidence-based arguments, not theoretical arguments. That's my first point. So my second point is that there is a problem. I think one of the common problems all the panelists identified was the lack of transparency of essentially corporate jurisprudence and the problem of governments trying to manipulate terms of service to create nice low margins, right? So that even more gets censored or taken down than what would be taken down under respectable judicial precedents, right? Where you would have an adversarial process and some transparency and sunlight on it all. And that's why the issue, Mark's call for legislation is important, because putting the onus of these decisions, whether they are solved through international law or, Westphalian territorial limits, whatever, it has to be placed back on government. It has to be put to voters and enforced by courts, whose decisions can be appealed, not by companies. And I think that's very important to realize. And when we have administrative bodies and corporations instead making non-transparent decisions that affect everybody's right to free expression everywhere, it's a problem. It's a human rights problem, and it's not going to be answerable simply by the margin of appreciation.
Okay, thank you. Good contribution. Can I go back and then forwards again? Sorry. All right, we'll stick with this table, then go to the table behind.
I think different cultures can have different contours of privacy, and they should be respected. The same fact pattern, a homosexual person participating in a pride march, media coverage in New York was not ruled as a breach of privacy, but a magazine coverage in France was considered a breach of privacy. I think different countries can have a different conception of privacy. The problem with this new movement of right to be forgotten is it's not about privacy in that sense. It's more about relevance. It's more about whether somebody's information is relevant to others. But the problem is, when you talk about relevance, the way you use the term relevance is it's got to be relevant to something, right? But we cannot talk about relevance as a standalone concept. It has to be relevant to something, but different people can find different relevance from the same information. Mm-hmm. There is no way of cataloging all the possible uses of certain information. For instance, Costea's auction information. Some obscure researcher of judicial reform in Spain may find that information very relevant and useful. I think that we can cool down a little and accept that people, the countries and cultures can have different conception of privacy, and we should talk about how to best respect that. But going down the way of finding what is relevant and what is no longer relevant, I just don't think is the correct way of respecting different conception of privacy.
Okay, thank you. Good point. Yes.
I have a short question. I hope it will not induce transatlantic emotions. Because there was another issue, I think, which is important, which is on encryption. It's a question. I also see that some journalists, people in human rights organizations, they share with each other encryption material. My first question is, don't you put yourself in the spot by using encryption material that security and intelligence services start monitoring? And secondly, I hear from people in the environment of intelligence and security services, I don't tell who my sources are, but they laugh with this kind of level of encryption by investigative journalists. They are so sophisticated, they have so much know-how that they tell me that they can easily, so it gives a false illusion of protection of speech. My question is, I don't know, I'm not a specialist in this, there are experts here, what is the level of security of these encryption systems for human rights activists and for investigative journalists?
Rebecca.
Sure. As a former journalist and someone who works with citizen journalists, I can take a crack at that. I certainly know people in a number of countries, including China, who say that they choose not to use encryption because they don't want to draw attention to themselves. But that's a choice. There are also other people who say that they are alive today because of encryption. I would point to some of the people who haven't been killed yet from the citizen media group Raqqa is being silenced. That, the reason any of them are being are still alive has to do with encryption. So it's a choice. It depends on your specific circumstances, and everybody has to really conduct, and I know that Emily's center kind of looks at this. You have to create your own threat model. You have to figure out who your adversary is and how you protect yourself. But yes, encryption is not some kind of magic cloak, that the Hobbit puts on and is invisible. It's and you can be leaving a trail by other means. So for instance, you might be using encryption, but perhaps you clicked on a phishing link and keyloggers got installed in your computer, or you kind of left some breadcrumbs on your Facebook conversations. There are ways that people can track you, which is actually why the Berkman Center for Internet and Society recently came out with a report saying that this debate about going dark is kind of beside the point, because there is so much information out there about people that can be tracked by a sophisticated data miner, that the fact that many people are using encryption, is not a huge obstacle for law enforcement, but it does protect us from identity theft. It protects. If it's used properly, combined with other measures to protect one's security, defensive measures. The spooks would call it OPSEC. That you can protect yourself with it, and I know people who would be dead today or who would be in jail today if it were not for encryption.
I agree with Rebecca. It's also making the haystack bigger, because yes, even if they actually get your keys, you're just making it difficult for them to just take it all. And just not encrypting your email, but it's also about the regular operational security measures one uses. So if you're running a law firm, then how do you actually communicate with your clients? And then how do you exchange data amongst each other? You may be using a chat service, which is probably not using end-to-end encryption. So you are leaving out some of this. But it's making it difficult. When there will be so much of gibberish, how difficult or how much resources people who are not actually trying to get into it for purposes they should not be, will it be difficult for them? That's why I said, to Agnes's point, online harassment is an issue, and it is the next thing which we have to watch out for. It is big, but coming just from India, and I have an experience, and it's not anecdotal, it's not about child pornography, it's a very different experience. Section 66A, declared unconstitutional last year, I'm sure Chinmay and Karuna have talked about it already, we were all part of it. It was brought in, it's again going to be brought in because women need protection. First time spamming, and women need protection online. Or there is so much of harassment going on, we need a law. So what happens is either knee-jerk reactions from the governments or use of law as an excuse. When the law was on the books, most, and all I would say, I won't say all, but most of the incidents or uses were for political censorship.
Right.
Can I just pick up something which is completely different but on point to Dirk's question, which is a lot of people are missing a very important point about encryption. The threat models and all the rest of it, I don't need repeating, but they are very important. But there is something called the Wassenaar arrangement. Not the Wassenaar agreement, the Wassenaar arrangement, they're different. But basically, this puts restrictions on most of the world to either export, take with you your laptop with encryption, PGP or Tor, or something like that on it. You usually need a license requirement, or it has complete illegality. The only exception is for personal use. But if you're a journalist or you're working for an NGO, it's not personal use. So they can criminalize you immediately.
Yeah, I just wanted to make a quick point about government surveillance. You know, I'm really struck by the fact that when we look at the horrific attacks in Brussels and in Paris, the Boston Marathon, each of those incidents occurred because of the failure of human intelligence. It was the failure of the government officials who were supposed to be keeping us safe. And one of the reasons when you speak to them that they talk about the difficulty in actually doing their job is because they describe it, as Mishi said, as the data, as, you know, trying to find a needle in the haystack. And yet their response is basically to say, give us more hay. And I can't understand really why, you know, when we hold these agencies and officials accountable, we aren't really focusing on the fact that they are failing to do what they are supposed to be doing. And it's not because they don't have enough data, it's because they have too much and they don't know how to handle it or use it effectively.
Well, I think I'm just going to point out that Bertrand had a taxi. It's not because he's taken great transatlantic offence that he's left. Though I have to say, as somebody who's a British who's lived in America now for 5 years and is just applying for a green card, this whole conversation has made me reevaluate my own status. I just wanted to say thank you very much indeed, first of all, for your engagement, which was an incredibly good and rich discussion. It's always a great thing when you end a two-day conference saying we clearly need another conference, just on the right to be forgotten, but that's certainly a point. And I particularly want to thank everybody on the panel for really an extraordinarily energetic discussion at this time. So thank you very much indeed.